Mein Bildschirm. Yes, hello. Welcome to our third and last part of the CSA legal workshop. For those who have not joined part 1 and 2, the motto of this year's event is Bridging the Gap, Reality versus Expectation. So now hello, everybody. We are going to wait for another 1 or 2 minutes before we start. Well, now, hello once again to our third part of the legal workshop of the CSA Summit. And our motto of the today's workshop is, for those who have not yet joined part 1 or 2, this is Bridging the Gap, Reality versus Expectations. Well, I'm your moderator for this day, and first of all, I want to give you some information on our housekeeping. So this is, first of all, as you have seen in the last sessions, you are muted during the webinar. You can ask questions using the chat function in the control panel at any time. And questions that need to be answered right away will be passed to the speakers immediately. We worked out some surveys and we would like to invite you to participate in here. We will present the results directly afterwards. And at the end, there will be a Q&A session. So now I come back to our motto of this year, bridging the gap, reality versus expectations. We want to help you bridging the gap in your daily business. And here we focus on issues we determined when dealing with complaints or during certification process. Now I would like to present you our speakers of today. This is Alexandra. She's an attorney and head of the complaints office. She monitors the report handling. She is in contact with the complaints and certification committee, and she is responsible for the review and update of the CSA rules, and she's regularly a speaker at the summit workshops. Then there is Sebastian. He is assessor of law. He works as a consultant for the complaints office. He's responsible for report handling, and since some years he is a speaker at the CSA summit. My name is Astrid. I'm attorney and responsible for the legal advice at the CSA. I do the legal checks during the certification process and presentations, and I'm your presenter for today. So now I hand over to Sebastian.
Yes, all right. Thank you, Astrid, for the introduction and the warm welcome. And hello, everybody, from me as well. Again, here you see some beautiful statistic numbers from last time and the week before that, in case you've been there, which I hope you have been. So we've talked about the big chunks already, the permission data and documentation problems, consent and customer relationship related problems. So what we're left with today is the last two bigger chunks, which are highlighted right now, which are the imprint and opt-out notice chunks. And those, well, as you can see, 16%, 10%, we base those off of the complaints cases that we had last year. For the ones who don't know this yet, we've had a couple of hundred complaints cases that ended in notifications, that ended in violations, and out of those, this was the percentage that was about these two subjects. So this is why, as the last two bigger chunks, we've chosen this for today's session to take a deeper dive on. So we're going to start with the opt-out notice, both in regards to consent and customer relationship, and then in the end, it's going to be an exciting time for the fans of the imprint information. All right, so let's head out for the opt-out notice, starting with the one regarding consent. So what does it mean? Why are we talking about this at all? So let's start a little bit at the beginning, I would say, for the reason why do we have to have an opt-out notice in the context of a consent declaration for email marketing purposes. As you've heard us say quite a lot, an important thing about consent declarations is that somebody who gives consent does so in an informed manner. So they need to be informed to what exactly am I consenting and who am I giving the consent to. We've talked about all of these things in regard to sponsors, in regards to things like what am I going to be receiving advertising for. So all of these are parts of being informed. And the last part that we've not talked about yet is the information about the right to opt out, because somebody who gives consent has the right to revoke that consent too. So this is why before giving consent, you need to be informed, or the user needs to be informed that they have this opt-out right, this revocation right. Which brings me to the first point on the slide. It needs to be placed together with the consent declaration, is what we usually say. What that means is before you give consent, you need to be aware of your right to opt out and how to do it. We'll come to that in a minute. But together with doesn't mean 20 minutes later. It doesn't mean one website later. It doesn't mean any of that. It means right then and there, before you make a little check mark and press send. This is where the opt-out notice needs to be. Then an important part is the how-to, our second point here. It's not really of value if I tell you you've won a car and can pick it up at any time if you don't know where to pick it up. So if you know about your right to opt out, to revoke your consent, and I don't tell you how to do it, it's not of much value. This is why the how-to is a big part of the opt-out notice regarding consent declaration as well. And well, in the third point just informs you about the fact that, of course, the opt-out notice is always in regards to future effect, of course, because if I tell you I don't want any emails anymore, please, then of course emails that you've already sent are not affected by that. That is quite a given. Another point that is important, not really on here, but belongs to the informed part, is the how-to implementation. So just telling you how to do it is also not worth so much. If I tell you to opt out, you need to go fight 2 big warriors and then swim a moat full of crocodiles and then press a button on the other side of that moat. It's not, factual. So it needs to be easy, is what I'm going to say. It needs to be as easy, as a rule of thumb, as opting in. If I give you the option to just click a button, then I have to give you the option to just click a button to opt out as well. No logins, no sign up information used, things like that. All right, this was the third big point that I wanted, or the fourth big point rather, that I wanted to talk about in this case. So I'm going to give over to Alexandra for the customer relationship opt-out notice, which is kind of different.
Thanks, Sebastian. Hello, everybody. Yeah, let's continue with the opt-out notice concerning the customer relationship. One could say same, but different. You already learned in the second part of our webinar series that the consent and sending advertising emails based on customer relationship have different legal basis, and it's just a consequence, of course, from a legal point of view, that even the opt-out notice is slightly different in its requirements. So one could make things easy. Lawmakers, unfortunately, often did not. So you have to have specific requirements here. So when we are talking about the opt-out notice concerning the customer relationship, the first thing I want to mention here is that you have to put this notice at 2 stages, so to say. First, when you're collecting the data, you have to inform the data subject, and also when you're using the data, so meaning sending the advertising email, you have to put a specific notice in there that the recipient can opt out. As in regards to the consent declaration, of course, you must give some information how people can opt out, because otherwise they are not fully informed about their rights. So the same applies what Sebastian just mentioned some seconds ago. The really strange thing is that you have to have a specific wording in regards to the opt-out notice in regards to incurring costs. So it's not sufficient what we often enough see when we are handling reports, that people say, okay, it's free of charge. I'm quite sure that every user, every data subject completely understands what it means, but that's not what the lawmaker thought you should give as information. The lawmaker just want you to put in some specific wording, which are on the slide too, and they are without incurring costs other than transmission costs at base tariffs. I know it's terrible wording. I know it's really awful when you think about the design of your email. Anyhow, these wordings are required by the e-privacy directive. There are court decisions concrete stating that you have to use this wording, and looking in the future, there are also these wordings in the draft of the e-privacy regulation. Whenever it will come into effect, there will still be the requirement of using these specific wording. So that's the theory. From theory to some practical issues. So we just picked 3 things we want to talk to you a little more in detail, because we think it's important to have these things in mind when you think about the implementation of opt-outs and opt-out notices too. So first, we want to start with a little survey in regard to the issue of double opt-out. So think about the following scenario. You have a brand B that reaches out to you because they want to avoid that recipients unsubscribe by mistake, for instance, by accidentally clicking the unsubscribe link. So they asked their ESP E to implement a double opt-out process. And if you were E, what would be your answer? So it's not about right or wrong here. We just like to ask you to pick the answer that you would give to get an idea of the feeling and the situation in practice. And afterwards, we will talk about some points in regard to the double opt-out. So I think the survey is up and running, Sebastian. He's nodding.
Sorry, yes, I mute myself. Yes, it's up and running, and some people have already voted. So take your time for a couple of seconds more, I would guess, and then we'll see what people answer. So far, I can see people have very strong opinions.
I can imagine, yes.
All right, we've got some answers, so I'm going to close it now. Thank you, everybody who voted. All right, Alexandra, back to you. This is the results. I think you can see them now.
Okay, funny, completely different than I expected in the preparation of this third part. However, no one thought it's no problem, okay, and the majority is in favor of it's prohibited by law. So let's have a look into the details. So first I want to start with some personal things on that. So I think it's completely understandable that people are thinking about the double opt-out procedure, because accidentally unsubscribing is a bad thing. Of course, it can happen if you're forwarding an email to a third party just to inform someone, and then they just want to click on the advertised link and they are just doing by mistake clicking on the wrong link, so someone unsubscribed and all that stuff. And of course, sometimes one just want to make people think twice before unsubscribing, so that there's the situation where you think about it. It's completely understandable from my point of view. Legally, you have to consider the following. Sebastian just talked about it some minutes ago. The opt-out option must be as easy as the subscribing process. So if you just implement a single opt-in, for instance, which still is the case, at least as far as we know from the complaints procedures, there are still some cases when we receive the information that the consent was declared by a single opt-in only. Then, of course, you're not allowed to implement a double opt-out process, because this wouldn't be as easy as the opt-in process. So that's something you really have to have in mind. If you're just doing double opt-in, for instance, the double opt-out would be as easy as the opt-in process, and from that point of view, it wouldn't be a problem. Anyways, I just want to recommend to you to think about the reputational issues that might come up when you're implementing the double opt-out process, because people could be annoyed when be confronted with these procedure. They just want to have the email stopped as soon as possible, the easiest way as possible, so they can just stop the opt-out process, and instead in the future just click the spam button when receiving another email. So that really could have a negative impact on your reputation. And these kind of procedures can also be in contradiction with other best practices. Just think about the one-click list unsubscribe options. that a lot of mailbox providers see as best practice, and which, of course, in our CSA criteria are also mandatory. So it's a kind of conflict of interest, so to say. When you just asked me what would you do, I would just give you the recommendation not to implement the double opt-out. So it's a good result we have. So obviously, at least the audience wouldn't cause any problems in the future in this regard. So let's talk a little bit about the idea of sending confirmation emails. And as in regard to the double opt-out process, we want to start with a little survey. So we have the following scenario for you. Brand B heard that it's always good to be responsive and just ask their ESPE to implement a confirmation mail for the opt-out request. It should state that the opt-out will be implemented in the next 24 hours and how one can subscribe to the newsletter again in case someone accidentally clicked the opt-out link. So the time when the opt-out would be observed, and otherwise, if it's by mistake, how you can again subscribe to the newsletter. So again, it's up to you. If you were E, what would be your answer? So Sebastian, it's up and running? Yes, I see it.
It is up and running, exactly. Yeah, we've got some votes, but please choose in that scenario as an ESP. Imagine you were one. Please let us know what you think. All right, they're coming in, Let's give it a couple more seconds. It's not that hard, just click one of the little circles. Go ahead. Yes, there you go. All right, I'm closing it. And back to you, Alex.
Okay, in this regard, there are obviously more ideas and opinions. However, the majority would implement the confirmed opt-out information. Even there might be reputational issues. And the second place, so to say, goes to the answer. It's no problem, I will do that. Okay, let's have a look to the confirmation mail. The first thing I want to state here is that, of course, from a documentational point of view, it could be a transparent way to inform the data subject what happens. So just confirming that the request was received and that it will be implemented could be a good approach to just confirm, that you will comply with the requirement that you take user rights very seriously. However, two things should be taken into account. The first one is if someone just asks you to stop sending any emails, so not only advertising emails, but any emails, that will mean that you're not allowed to use the personal data anymore. It's unfortunately also includes that you're not allowed to send opt-out confirmation mails. So always have a look what people just want. Do they just want to stop receiving the advertising email? Then it's fine to use the data from a legal point of view to send the confirmation mail. If they just want to stop you to use their data in any kind of potential use, then you're not allowed to send the confirmation email. There's one kind of obstacle, so to say. The confirmation mail should not include any kind of advertising, and just looking back and remembering what we presented to you in the first part of our series is that there's a very broad definition of advertising. We talked about this in detail, and even just including a link and information how one can subscribe again can be advertising. So if you're implementing the confirmation mail, please be as neutral as possible, because otherwise you will run into the permission-based legal issues you really don't want to have. So be as neutral as possible. have a look what the data subjects really wants, and then decide whether you implement the confirmation mail. That's from the legal point of view. From the reputational point of view, and so I'm quite happy that people obviously thought about this when answering our little survey. Even receiving this email can mean that the user is very annoyed and is just clicking the spam button in the inbox. So there's a little risk that people don't want to receive this kind of information, even if it could be of advantage for them to get acknowledgement. So the last point I want to raise here is that think about the implementation of opt-out requests in a very short period of time. In the CSA regulation, we decided to give you 5 working days at the latest. However, if you are faster, of course, that's better. So have this just in mind and don't, prolong this period, because otherwise you really can get problems, not only with us, which is of course bad enough, but think about data protection authorities that could get this information, or even people going to sue you, and then you will have very bad court decisions, and I think that can be avoided very easily. That's from the opt-out part. Oh, I get a slide. I get there's a question, Astrid.
Not a question, but a comment that I would like to give you here. There's someone who is not so very happy with spreading the word that double opt-out is an acceptable behavior. So for him, it seems to be a little bit difficult to implement this, and maybe you could give a comment on this.
As stated before, my recommendation would also be don't do that. It's just what we wanted to present you, that there might be a way to have this implemented from a legal point of view completely correct, but just thinking about the reputational effects it will have, and of course from a user's right perspective, which is not our guiding perspective here, but from a user point of view, I wouldn't be very happy to click I really want to unsubscribe. And of course it's contradicting to other criteria as the list, one-click list unsubscribe. So that's the word I was looking for. So we wouldn't recommend it, but it's an issue that comes up from time to time. So we thought it's good to talk about this here when talking about implementation issues. Okay, then I would hand over to Sebastian to talk about the imprint. So Sebastian, the floor is yours.
All right, thank you. Yes, the moment everybody has been waiting for 3 weeks. Everything you wanted to know about the imprint information, or the legal notice, the footer, whatever you want to call it. In Germany, we call it the Impressum, but I think it speaks, for the fact that there is no perfect English translation for it, because it's kind of a German thing, I guess. But as we're going to learn, it's not a German only thing. So what is the imprint information? It's basically all and I use this as a technical term, all the legal mumbo jumbo that is at the bottom of any email. In the footer, you always have this text stuff that kind of identifies the sender. And there I go. This is the first point and the most important part. Why do we need this? This is annoying. I don't like to implement this. And every time I hear from the CSA about it, I get my finger slapped because I did it wrong. Why? So the idea behind this, we've talked about being informed before you give consent, and information is what is the key word in this case. We want to be informed who is sending email to us, or anybody does. It goes the same for if you are a contractual partner with somebody, you want to know what exactly is the company. So we're going to go through all the points. Don't worry, I'm not going to do it entirely dryly and theoretically, but we've chosen to just present you an example imprint information or impressum, which you can see already. This is our own, and of course we think ours is good enough to share and use it as an example. So as I've said, you need to be able to identify the sending entity or the entity that is corresponding with you. And in the case of an advertising email, of course, that's the sending entity, or usually the one that is either the technical sender or the content provider of that email. So right in the first couple of lines, you see exactly that. For us, it's of course the Echo Association, and there's a physical address there. And the first thing you see after that is email and telephone number. So there's different rules all over the world what exactly needs to be in such a legal information. So the CSA has taken what is basically more or less consensus all over the world, and what is kind of specific and special and relevant for email advertising. And of course, that is some sort of direct communication, not via postage. It doesn't make sense to, for example, opt out via a physical letter. Doesn't make any sense. So we've put in, as some local laws actually do, the requirement to have both an email address and a second way for direct communication, which can be either a telephone number, such as in this case, or an electronic contact form, which is kind of hard to implement in an email, of course, which is why a link is fine to a contact form. Putting a whole contact form inside an HTML email, I guess, is technically possible, but please do not do that. I think that's quite dirty coding. I wouldn't recommend that. I don't think it's fine at all. So take this as the joke that it is. Please don't do it. Some more information is on here. This goes to show, like, for the next two lines is association registry number for Echo and our VAT ID. Those are things that are required by our local law. So it might be different in Austria or the US or Australia or China. Those are things that need to be in there, yes, but they are dictated not by the CSA or by email specific legislation, but for us, because we're situated in Germany. Same goes for the last part, and this is a very fancy way to tell you our legal representative, basically, which in the case of Echo would be both our executive board and our CEOs. This comes from the history of this kind of information or imprint legislation, which always wants to ensure that you can technically sue. Yes, we're all lawyers here, but we don't want to sue anybody, but we want to be able to. So in Germany, you can't really sue a company if you don't give the court the name of the legal representative. This is very simplified, of course, so please excuse me, but if you want to bring a lawsuit to a company, you need to name a legal representative. So this is why in Germany, for example, the legal representative needs to be in a legal imprint. But I see that we might have a question, and seems some gestures over there.
Yes. So the question is, I think, concerning the presentation of Alexandra before. So should there be an opt-out link in transactional emails? Or maybe this is a question that concerns both of your presentations.
Okay, yeah, I'm just thinking about switching to the Q&A session right now, or just loading the remark.
No, you're right. I think let's just put that into the Q&A, but we're almost done here anyway. So the one thing, let me just say that before we answer the question, the one thing that I want to add for the imprint information is, and this is not entirely unimportant, please have that both as full text, not linked in emails. This has been a CSA regulation rule for some time now, over a year, I think. And also, we always say it needs to be easily recognizable. If you want to break your tongue, say that 3 times. So it needs to be easily recognizable. So please don't put it in like type 2 wording and in light gray on dark gray or something like that. So upside down, I've seen that. No, it's no joke. I've seen upside down imprints or in a picture, anything like that. It needs to be in full text, full stop. All right, now we're going to go to the Q&A anyway. So this is perfectly where we're going to go into the first question then. Thank you for asking that, by the way.
So opt-out in transactional mails, if I remember correctly. So the point is transactional emails are typically no advertising emails because they are just about sending invoices, for instance, or shipping notifications, changes of terms and services and all that stuff. So when you're just thinking about implementing the opt-out link here, is the first question I have in my mind. Why do you want to have an opt-out in a transactional email? Because typically there's no need to unsubscribe. You don't want people to unsubscribe from receiving invoices, for instance. So if you think there is a need to put an opt-out notice or opt-out link in a transactional email, the first thing you should do is check your transactional email, whether it includes advertising or not. So that's the first answer recommendation I want to give here. I don't know, Sebastian, if you want to add something additionally.
Yeah, sure. Just, I mean, on first glance, I would agree. Of course, it's not. I would ask why. It doesn't make any sense. It doesn't fit together. And good recommendation, Alexandra, to just have that as a point where you start checking: is that actually a transactional email? Does it need opt-out, which would make it probably an advertising email? So. Yeah, but I want to stress that, of course, you can put it in there. It's not illegal. It's not bad. It just doesn't really make any sense. But for example, you could have it in a double opt-in email, which could be argued as a transactional email, and then it would maybe just, you know, be a way for the person that is receiving that email to opt out even before they get their first email, which would actually be a good thing. So depending on the situation, it might make sense. Maybe that's a good summation.
So I think we have some more questions here. The first one is, can the opt-out notice be linked somewhere, for example, to terms of services?
You want to start?
Yeah, sure, I can start. So can the opt-out notice be linked, for example, in terms of services? The answer is easy. It's yes and no. Yes, it can be linked to. We've said that the opt-out notice has to be somewhere around the consent declaration, so you can make your consent declaration in an informed manner. But you shouldn't hide it. You should be able to find it. So if there's just a link to, you know, terms of service or data protection things, then and without any reference that there's information about the opt-out or how to do that, then that wouldn't be enough. But if there's a little link that says you can find more information about your right to opt out and how to do that here, then that's totally fine. But I mean, if you're going to write all that, you can just write the actual notice right there. It's just a recommendation, but it's not impossible to link to that. But thank you. Good question.
I would second this and just give the additional information or input that when it comes to the customer relationship-based advertising, and you're thinking about the different requirements for being allowed to send emails based on this exceptional case, that you really need to inform the user that you are planning to send advertising emails when collecting the data, which means when typing in my name is, and this is my email address, blah, blah, blah. And if you're just putting here the information, of course, it's very important to make it really clear how one can opt out. So I think, of course, you can put in the sign, okay, further information can be found here, and then link to the terms of services. But as you already have the obligation to put all the information very close to the data collection, it would really make sense to put everything directly there.
So here comes another question in the context of transactional emails. Would you say you have $100 in your betting account, use it before the credits expire by date? Is this transactional or is this advertisement?
I would say this is clearly no transactional email, but it's already advertising because you're aiming that the people just spend the money. Yes, so it's not about only the information, you have the amount X, Y, that. It's just about spending this. And that's, of course, advertising. Think about the broad definition. Even indirect advertising is advertising, and you need to have consent.
Adding to that, I would agree. Just giving the case as if you brought it in that question that broadly, that would be advertising. Yes, it depends. You know, lawyers like to say it depends. Of course, if there's some sort of legal obligation, like for example, there's between the service provider and the client, there's some sort of legal agreement that you have to send every, I don't know, 2 days, 5 days, 7 days, you have to send them an email and tell them you have this and that many credits, or you need to tell them this and that many days before they expire or something. If you have a legal obligation, then this might be considered a transactional email. So it's not that black and white, but you know, it's always a good rule of thumb to say, do I have a legal obligation to send this email? Then it's probably transactional.
Of course, depending on the wording. So in this case, it was just, at least in my point of view, very clear that it's not about only informing people because of an obligation. So think about the wording if you have to send such kind of information to users.
So another question in the context of transactional emails, which seems to has a very high interest here. So does the sender has to provide a list unsubscribe header in transactional emails? Is there an obligation for this?
So the first thing I'd just like to state here, I'm really surprised that we talk about transactional emails today and not 2 weeks ago. However, of course, we are more than happy to answer your questions. So transactional emails and list unsubscribe headers. This refers to the CSA regulations, I guess. I really don't want to talk about the current situation because we are just changing the rules and regulations, and we expect to send out the new versions within the next few days. And of course, when sending out these new regulations, we will already use the advantages of changes for you, even though normally they will just come into effect 6 weeks after. That said, what we will change in the future is that you can not really choose, but you don't have to ask for an exception in regards to transactional emails if you want to put in a list help header here. So there's no need to put in the list unsubscribe in regards to transactional emails, because usually it's not about lists who are where emails are sent to, because transactional always mean there's a specific reason for reaching out. So typically you don't have a list, so list unsubscribe doesn't make sense. But what really makes sense and what we really want you to do is implement in a style pattern so people know why am I not able to unsubscribe here. They need to get the information why they are receiving these emails and yeah, why there's no need for unsubscribing. Hope this was clear enough.
So I will give you another question, which means why are the rules for the opt-out notice wording so strict in the case of a customer relationship?
I just could say and make it very easy. We lawmakers, I'm quite sure you don't want to hear that answer. So the first thing is we are talking about exceptional cases here. And typically, if you talk about exceptions, then the requirements are very strict. And that's one of the reasons why lawmakers just put in very strict regulation here. That's also the reason why courts just decided, okay, you need to have this specific wording in your emails and when collecting the data.
Another question is, what about internationally different rules for legal notice or imprint information? I think this is a question for Sebastian. So
Yes.
some points might not be mandatory in country A, but still in country B. Could you give some?
Yeah, exactly. That's what I meant when I was making those points about the local laws being applicable. For example, these things that need to be there in Germany, like the VAT ID thing and the legal representative, that those might not be mandatory in other countries. But let me give an example of, I don't know which country, I don't want to tell you the wrong one, but there's local legislations that, for example, need to have the amount of the base capital for a company in this legal imprint information. Not so in Germany, but in some other countries that might be a rule, for example. Or I don't know, you could make it up. There might be any local thing. So yeah, always adhere to the local law that you're situated in, of course.
Okay, thank you, Sebastian. We have another question here. What if you send an email with a mix of subscribers and customer relations? Do you have to have the text included or create two different emails?
Maybe I just jump in. So you're saying you have people who have consented to get those emails and other people that you have a customer relationship with. And we've learned that only for the people that you have the customer relationship with, you need to have this specific worded text. I have seen during, working on complaints cases, a lot of emails that are actually based on consent, but still have this text. Let me tell you, it's not wrong to have this text. It doesn't really, it's not illegal. It still just informs them about a right that they don't really have in that sense, but it's not something, because it's worded in the way that it is, it's not wrong. It's still, if you want to opt out, even if you've consented, if you opt out, of course, it's not going to cost you anything, and it's going to incur only those costs of the transmission costs. So it's not wrong. You don't need to have two separate things. It's just not mandatory in the one case. It is mandatory in the other case, but it doesn't hurt. So I hope that answers it. Alex has some thoughts, apparently.
Yeah, I just have the thought that, of course, what we saw in the past is when things are mixed up in regard to the recipients, that you might run into problems with the promoted products here. So that's why I just struggled a little bit when hearing the question. The first question I would ask myself is, okay, am I really allowed to send the same email with the same advertised products to both groups of recipients? Because I don't want to repeat what we talked about last week, but you're not allowed to advertise everything when you're sending emails based on the relationship. So, as a side note and recommendation, think twice when you want to mix these group of recipients.
Okay, so here's another question. So that is going a question going into the future. By increasing the use of list help, does the CSA want to push mailbox providers to handle and display the information of the list help, like to clearly display the URL inside on the email on the webmail, like webmails are displaying a link for unsub based on the list unsubscribe header?
The good thing is we are all lawyers here, and our technical head, I don't know if he's at the attendance list and just listening to us. To cut things short, I think we will take these questions and we'll answer this after the webinar, because I don't want to give any answer here without consulting our technical head in this regards too. Just, yeah, please understand, we will postpone the answer here.
So we have yet no more questions. So first of all, I would like to thank you for your very interest in our third part of the legal workshop. And so if you, we would say, please stay for a while in the session. And if you like, you can give us a feedback on the third part of our legal workshop. Alternatively, you can also give us a feedback in return to the email that you will receive tomorrow. And of course, please do not forget to register for our other CSA email summit events. Thank you very much for joining the legal workshop of the CSA, and hope to see and meet you next year. Thank you very much.
Thank you. Bye.
Bye.
Bye. Bye.